Okay. Okay.
I know Emily was trying to work something out.
Okay. Let me talk to Ms. Ladd, Your Honor.
Okay. All right. So this is in the matter of the people of the state of Michigan versus Samantha Diane Ladd. File numbers 22-20962FH and 23-21239FH. And Rhonda Underwood appearing on behalf of Miss Ladd. So I'm going to open up a breakout room and pop you guys into it. And find you, Underwood. And all right, hold on a second. Gotta get the right Zoom room in there. There we go. All right, go ahead and join that breakout room. All right, Mr. Van Melligan will be with you in a minute, all right?
Yes, ma'am. Yeah.
Thank you.
No, that's enough.
What'd you say, Mr. Van Melligan?
I'm sorry, I was talking to the deputy here a minute. Sorry.
Oh, okay.
There you go. There it is. Yeah, the stuff you like to look at. Yeah. Yeah.
Okay. All right, Mr. Milaro, you got Mr. Raymer. Who was your prosecutor on this one?
It varied, but I think one of them was Mr. Sears. Another one may have been Gumtow. Another one may have been Bayonetto. Varied.
Mr. Sears is at prosecutor school.
His what?
He's in Lincoln Safer Prosecutor School. Just so that you know.
Hold on, Miss Underwood, I'll be right with you.
Thank you, Your Honor.
Miss Adams, Mr. Malaro filed a timely sentencing memorandum back on May 13 of 2025, disputing guidelines on Mr. Raymer, and I think you verified there was no response filed, but perhaps I've tried to reach somebody in the prosecutor's office. I don't know if one of them want to pop in and
Okay.
chat.
Tell you, John, if they can leave whenever they can, you know, go reason. Go for you.
Okay. So, Mr. Van Milligan, I'm gonna pop you in the waiting room because
Okay,
you're talking to somebody, so. All right, so we're back on the record with Miss Ladd. Miss Underwood, you've had a chance to speak with Miss Ladd.
Yes, Your Honor. I also had the chance to look into the confusing note. Your Honor, Miss White is working with Miss Ladd on rehab, but what she needs for CMH is a document from the court that she can be released to rehab. So that's what's holding up the paperwork in this matter, Your Honor.
So what are you asking of me?
I guess if we're going to do a sentencing to rehab, that be put down, or, you know, because that's how they deal with releasing people from jail. When Ms. White does it, she goes through CMH and that's their process. So we need something from the court, whether she's sentenced today or whether she's sentenced in the future, that she can be released even to rehab.
Okay. Inpatient treatment.
Yep.
So her initial. So she was originally sentenced on June 23rd of 2023 to a 3-year term of probation. The recommendation today is that okay. So Ms. Walsh, obviously Ms. Ladd is now trying to address some addiction issues and a rehabilitation program. Your recommendation is 1 year in the jail, revoke her 7411 status. And I don't think that's unreasonable, Ms. Underwood. Of a recommendation based on her past history, if I give her a chance to go to rehabilitation, if Ms. Ladd leaves that program, if she doesn't complete the program, if she gets kicked out of the program, and she doesn't continue with a better outlook on probation, we're gonna be back here again, and Ms. Ladd needs to understand that. Or are you asking for her probation not to be continued?
Your Honor, I believe this was discussed the last time, and Ms. Ladd understands that she gets one chance. This was discussed at our last hearing.
Been in front of you several times and given several chances that I've taken for granted, and
Hold on, Miss Ladd, hold on. I hate that room that you're in. It's the worst room at the jail, so scoot on up and give me just a minute, okay? So don't worry, you get a chance to speak. Give me just a minute. All right, anything else? So Miss Ladd, did you get a chance to read and review the probation violation report?
yes,
Did you get a chance to talk to Miss Underwood about it?
Last court date, yeah,
And then you were in a breakout room with her today?
correct.
Okay, so you've been able to speak with her, do you need to speak with her anymore?
I don't think so. I thought we already knew what we were doing by last
Yep,
court date.
yep, are you satisfied with Miss Underwood as your attorney and
Yes,
the
ma'am.
advice that she's given you?
Yes.
All right, Miss Underwood, is there anything you wish to explain or challenge in the violation of probation report?
I don't believe so, Your Honor.
All right, is there anything
you-
else you'd like? Hold on, Miss Ladd. That room just has really bad audio. That's all it is. So, Miss Underwood, is there anything else you'd like to say on behalf of your client?
Just that, as we discussed last time, and as Ms. Ladd really put to the court last time, she realizes that Ms. Walsh has done a great deal to try and help her. And she also realizes that she's taken it for granted. But I think this time in jail has really made Ms. Ladd be clear-headed and grow up. And she really wants the advantage of rehabilitation in this matter, Your Honor. We would ask that Ms. Ladd be approved for inpatient treatment, Your Honor.
Now, Miss Ladd, is there anything you want to say on your own behalf?
Just that you've given me several chances and I've failed at all of them and time again. And I would like to just get some different type of help, some actual help, and instead of sitting in jail, so I can get her to be a better mom. And this jail stay's been horrible. I wake up every morning, go to sleep every night, worrying about if she's taken care of, if her needs are met. And so I just want to have one more chance and assure you that I do better this time.
So, Miss Ladd, you know, those are the things everybody wants, right? And so you haven't done anything on probation. And I will say about Miss Walsh that she will go to great lengths to help people who want to help themselves. But once she's done that and you haven't tried to help yourself, she is not, you know, she is going to punish you and by violating your probation, whatever. So just, you know, I immense respect for Miss Walsh and the length she goes to help people be successful on probation. So I'm gonna give you one more chance, but if you don't do it this time, we're gonna be back here and you're gonna do a year in jail and you're gonna lose your 7411. So it's a sentence of the court that you'll serve 1 year in the Lenawee County Jail. You can be released to an inpatient program. That'll be on both files.
So I am gonna do the year.
Actually, hold on 1 second. Hold on. No, I'm gonna release you to a program. So like if a bed's available in a week or two, you'll be able to go to that program. So I'm looking for jail credit. Hold on. All
It would
right,
be
so I'm gonna give you a
28.
year in jail on file number 23-21239. I'm gonna release you to a rehab program. Your probation will be amended that you're ordered to complete successfully that program. If you hate it, you don't get to leave. If you don't like the people there, you put a smile on your face like I do every single day dealing with lots of people we don't necessarily like, and you do the program. You don't get kicked out. You don't get in a fight. You don't sneak drugs in, whatever. You behave yourself, complete the program, get all that information to help you be successful. And then I will continue probation. I'm gonna give you credit.
It's an additional 20, I'm sorry. It's an additional 7 days from,
So it'd be
last
121 days,
yes.
121 days credit. On file number 22-20962 FH, I'm gonna give you 29 days credit on this violation of probation. And that's time served on that file. And probation continued. So you got a year to take advantage of this program, to take advantage of the opportunities Ms. Walsh has tried to provide to you. You know, Ms. Ladd, I know you don't want to end up where you ended up when you were a kid, right? We want to make those changes for our babies. So now you do have the right to appeal this sentence, and my bailiffs, or no, the jail is going to give you your notice of right to appellate review on each file, and just initial and date one copy for our records. The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Ms. Walsh, instructions for Ms. Ladd.
You need to contact me as soon as you're discharged from treatment, or if you leave treatment. Either way.
Okay.
Judge, I'm sorry, what docket did you give the 1 year on?
I give her 1 year on file number 23-21239.
Okay.
But she can be released to treatment, correct?
Yeah, now who's arranging that?
Excuse me, Emily White is, I guess the only thing she was missing was, somebody saying okay from either your office, Your Honor, or Ms. Walsh's office, is how I understood it. 'Cause we were on
It'll be
there
worked out.
for last week, but
No, they're good. Are you talking about the treatment program?
yeah, Emily was already here to speak with me. She just needs something saying from, I believe it's your office, Ms. Amblon, or Judge Amblon.
Emily, who does Emily work for? Your office, Miss Underwood?
Yes. And now
So
that she has
Emily works for the public defender's office, and she's the one that sets up the programming. So it might take up to a week as soon as a bed's available, okay?
Okay.
All right, so good luck to you, Miss Ladd. And hopefully next time I see you, we'll be in a good position, right?
Yes, ma'am.
Anything else, Miss Walsh?
Miss Ladd, when you get to a program, I need you to please try to remember to sign a release of information for me.
Okay.
Okay?
Okay.
Okay.
All right, good luck to you.
All right, thank you.
Thank you. All right, Ms. Underwood, I have Mr. Van Maldigan.
Thank you, Your Honor.
All right. And remove that room.
Yeah.
The worst room. All right, so, Mr. Van Maldigan, why don't you unmute your device and start your video for me, please? Maybe. You guys resolve it, or you need to talk to me?
Some of it.
Well, why don't you go back there and I'll be right back.
Okay.
No. We can't go in there, Rhonda's in there, that's her private office.
Good morning, Ms. D'Angelo.
Hi, I had Mr. Van Maldigan in room 5,
Yeah,
and he's muted and his video's turned off. And
okay.
I had to put him in the waiting room because he was talking, so.
Yeah, I had to take the mouse from him and my keypad because he was surfing, so.
Okay, all right, thank you.
I'll get him back in there.
Okay,
All right, bye-bye.
the client's got to stop looking at porn on the computers at the jail, you know.
Is that because Tom Moore got him to do that?
No. I mean, I can't even like go on eBay half the time, but somehow they're accessing porn websites. Oh,
Smarter.
it's always funny because depending on what IT needs to see, like sometimes I can get on Ticketmaster. Somebody on IT opened it up to buy tickets.
Your
All
Honor, can you hear
right.
us now?
Yes, Mr. Van Maldigan, can you hear me now?
Yes, ma'am. Yes, Your Honor.
Okay, so this is in the matter of the people of the state of Michigan versus Jeffrey John Van Maldigan, file number 19-19709 FC. This is the date and time scheduled for a violation of probation sentencing. Mr. Van Maldigan, did you get an opportunity to read and review your pre-sentence report?
Yes, I did, Your Honor.
Good, and have you had an opportunity to review that with Ms. Underwood?
Yes, I have, Your Honor.
All right, are you satisfied with Ms. Underwood as your attorney and the advice that she has given you?
Yes, Your Honor.
All right, Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
The only thing we would like to challenge, Your Honor, is the pre-sentence report says that Mr. Van Maldigan didn't report at all. Mr. Van Maldigan, I believe, reported in Ohio for a significant period of time. And then there was a point where I believe he went to jail, and after he got out, he never reported again. Is that correct, Mr. Van Maldigan?
Yes, Ms. Rosewood. Yes, ma'am.
Okay.
He wants to make it very clear he did not take his probation for granted this whole time. He really didn't. I recognize the recommendation in this matter is for a year in jail. I am hoping that the court would see fit not to give him that total year in jail, Your Honor. I do think that, yes, he deserves punishment for his violation. The court has to take these matters seriously, but I'm hoping that he would not get the whole year in jail, Your Honor.
Mr. Van Maldigan, is there anything you'd like to say on your own behalf?
No, thank you. I just sorry that I did that to the court, and Mr. Thomas Parker, you know, having to waste your time come back to me. You know, and I know I messed up, and I'd just like to say thank you for everything, and that's all, Your Honor.
Okay, so Mr. Van Maldigan, prior conversation indicates that you did report to Ohio a couple times after we tried to transfer it there, correct?
A bunch of times, almost 18 months.
Mr. Moore, were you able to verify any information with Ohio?
Okay, yeah, there's where the confusion's coming in here. If you look at the report, he stopped reporting after his release from jail the second time. Originally, when we looked at it, and then I got back into it, look, yes, correct. I transferred his probation to Ohio. He was reporting down there. He then was arrested on an old felony warrant brought up here to the Lenawee County Jail, where he was struggling with some substance issues. So when he was released, then we never did see him until now, since 2023.
That's September of 23.
Correct.
All right. So he reported for a while, and then after September
Correct.
of 2023, we never saw him again.
Correct.
Okay. All right. So that we talked about that before, Ms. Underwood, and that has been noted in the report.
Okay.
All right.
Mr. Van Maldigan just wanted to make sure the court was aware.
All right. So, well, Mr. Van Maldigan, you weren't incarcerated September of 23, were you?
No, ma'am.
Okay.
No, Your Honor.
So, all right. And so I appreciate that you did report for a while, but then eventually you did stop reporting completely for almost 2 years. So it's a sentence of the court that you will serve 1 year in the Lenawee County Jail. We'll give you credit for 7 days already served. I guess you have a current case in district court for possession of methamphetamine. We'll give you credit for 7 days and discharge you unsuccessfully from probation. Now, Mr. Van Mulligan, they're gonna hand down to you, or somebody's gonna give to you a notice of right to appellate review. Just fill out the initial and date the form. One copy will come to me, the other copies are for you. And if you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right, good luck down in district court, Mr. Van Mulligan.
Thank you, Your Honor. Thank you, Mr.
Thank you.
Osborne. Thank you, Tom.
Thank you.
Thank you. All right, so let me double check my, that's weird. I don't have Mr. Degemarco's in. Becky, did we move Demulin?
Let me check.
All right, so I'm gonna go back and chat with these two regarding Mr. Raymer. And then I will come back.
Judge, not that I can see. I don't see that it was adjourned.
Okay,
I saw Michael walk that way. so he might-
Miss Underwood, are you all set?
All set, Your Honor.
Thank you. Hey, Joanne. Here's credit senior pictures. We're not very good at that. Where is his file? They're weird though, because the schools don't do it, where you get it done and you have a bunch of faith. They don't do that anymore.
Right. These are so good.
Yeah. You're kidding. What a That's awesome. Will you get? Oh. Yeah, that's. Well, that'll be so cheap. Oh, siblings, my siblings. Oh my gosh. Oh my gosh. It's just cheap. I mean, I just think like, hey, really? Oh my gosh, that's awesome. Oh, good. Oh, good. Well, maybe you should be able to do your haircut. You never know. Oh, well, that's good. I'm glad. That's good. You deserve it. You do.
used to.
Okay.
Please rise for court sound session. Want to write down, Judge?
Oh, yes, we need him to.
8520. You can go ahead and bring him down, please.
I have to say the closed captioning that I have now on my system, so people can turn on closed captioning on Zoom, doesn't always track appropriately, like what you're actually saying. So. No. They are? No. You get yours. I was just showing you.
Yes, they're beautiful.
I think that when you graduate from high school, they should still do the nice looking headshot. We can order it through the school,
Right.
you know, with your name and the year on it.
Yeah.
And they don't offer that anymore. So you get your senior pictures done by some independent photographer,
Right.
and then
Yeah.
you gotta print them, but there's nowhere to print them
Exactly.
nicely, like,
Yes.
you know,
Yeah.
so.
Remember, you might have done, I never did these, but I always thought they were so good. Were the ones, especially the ladies with the black dress, you know, and then kind of.
Oh, with the pearls?
Yeah.
My mom's senior picture, she's like this. She's got a big bouffant,
Mhm.
you know, her pearls, and
I just thought those were so.
those are
nice.
always pretty.
Yeah.
Yeah. Hi, Mr. Hartung.
May I approach her?
Me?
Mr. Bennett, I'm Mr. Millar.
To talk to me?
Yeah.
All right, I'm gonna put the courtroom in the waiting room.
Don't know why I'm here, bro.
I don't know, you did something wrong. All right, Mr. Reamer and Mr. Malaro, why don't you step up there? Mr. Moore, this is also a Miss Teskey file. So, yeah, you can sit down if you want. All right, this is in the matter of the people of the state of Michigan versus Shane Leroy Raymer. File, we have multiple files, 23-21665. Well, no, we have one file, 3 counts. Today is the date and time set for sentencing in this matter. Mr. Raymer, did you have is the microphone down there? Yeah. Mr. Raymer, did you have a chance to read and review the pre-sentence report? You got to speak up for me.
Yes, ma'am.
You got to speak
All
up.
right, Mr. Malawi, he's going to have to stand at the podium. He's soft-spoken. It's okay. Okay. I mean, as long as he stands there, I'm fine. So attorney is always really loud. So you got to read and review the pre-sentence report? Okay. And are you, did you have a chance to discuss it with him? Okay. Are you satisfied with him as your attorney and the advice that he has given you? Okay. Mr. Malaro, well, first, Mr. Banetto, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Just just some of the OBs, Your Honor, whenever the court feels that that's.
No, I'm not there yet. Yep. But anything else? The only thing I would say is on page 1 of the probation violation recommendation, it does say he pled guilty to those counts, and we'll amend that to reflect
Judge, I don't know that there's a probation charge.
pre-sentence report.
You said probation violation.
Okay, but pre-sentence investigation report says he pled guilty. He was actually convicted at trial. Okay, so Mr. Malaro, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
The factual information, no, we would not change.
Okay, so I'm not talking about the guidelines yet. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect? I show he has no prior misdemeanors and no prior felonies.
We would agree with that.
Do you agree with that as well?
Yes, Your Honor.
Okay, so now we're going to talk about the guidelines. So Mr. Malaro filed a timely sentencing memorandum back on May 13 of 2025. I did not have a response from the prosecutor's office, but Mr. Banetto was kind enough to come up today. And so we had an opportunity to go through the guidelines using my copy of the State Appellate Defender's Office annotated sentencing guideline manual and discuss those guidelines. So Mr. Malaro, the first, if you'd like to start OV by OV.
Sure, Judge. Judge, with respect to the.
So let's start with the count 1 conviction of police officer assaulting, resisting, and obstructing, causing injury. Mr. Moore, there will be some changes to these.
So, Your Honor, with respect to OB3 on that file, we objected to the scoring. The basis was outlined in my sentencing memorandum on paragraph 4. And since it was, I believe that's the one where it's required to be an element of the sentencing offense. And since it is, I don't believe it should be scored. It should be scored 0. As to OB12, that one we scored at 5. We objected to that due to the contemporaneous element. And I emphasize if both of the following circumstances exist. So that was the argument that should be scored as 0 as well. It's our argument that on that charge, the PRVs are correctly scored at 10, but the OBs, it's our argument, should be scored at 0. I think if that accepts that argument,
all right,
then the guidelines go to 0 and 9.
All right, so Mr. Banetto, with regard to OB3 on the RNO causing injury, what is your position at OB3 being scored at 0?
Your Honor, I would defer to the court's discretion on that. We did have off the record discussions. I'm not sure how that would apply as it relates to OB3. Okay,
so OB3 in this case is physical injury to a victim. It was scored at 10 points. It was originally scored at 10 points. Bodily injury requiring medical treatment occurred to a victim. We did have a discussion about that. And in this case, we did not feel OB3 should be scored at 10, but instead 5 points because there was no medical treatment required in this case. He saw a doctor, but there was no treatment. And bodily injury is an element of this count. So 5 points could not be scored. So OB3 was scored at 0. And then we had a conversation about OB9. OB9 is number of victims. In this case, Mr. Malaro, I think you didn't address this one in your memo, but Mr. Banetto brought up he felt OB9 on this count would be properly scored at 10 because 2 to 9 victims were placed in danger of injury or loss of life. There were 3 police officers present that day, no charges continued for one of them. So that left us with 2 police officers involved in the incident. So I did score OV9 10 points. Mr. Malauer did object to that.
And we still did good.
Oh, thank you. And then OV12 is our next one. And OV12 is contemporaneous felonious criminal acts. It was scored at 5 points. Contemporaneous felonious criminal act involves 2 things. One, if the act occurred within 24 hours of the sentencing offense and will not result in a separate conviction. So I believe you had no objection. Is that the one you said Mr. Malauer was correct in?
Yes, Your Honor, I would stipulate that Mr. Malauer is right. And OV12 should be scored at 0.
All right, so we will score that at 0. So the PRVs remain at 10. The OVs will be 10, which the guidelines would remain at 0 to 17. So let's move on to the resisting, obstructing a police officer without the injury element. And Mr. Malauer, I believe your objections were the same. So do you wish to address them on that count?
Judge, we would just reiterate our objections as to OV3, OV12, and OV9 as well. I mean, the argument's the same.
Okay.
And I think the result, right?
All right. And Mr. Bandetto?
Your Honor, I will again stipulate to OV12 being scored at 0 and for the court's discretion as it relates to OV3. I believe OV9 is scored correctly as it was in the last count.
All right, thank you. So there were 2 police officers and 2 RNOs, one involving an injury potentially. OV3 on this one was scored at 5 points for bodily injury not requiring medical treatment, but that was addressed in the count 1. So on count 2, there was no bodily injury to this officer. So OV3 will be scored at 0. OV9, the court believes that was correctly scored again for 2 to 10 victims. So I will leave OV9 at 10 points. OV12, again, is contemporaneous felonious criminal acts. In that case, it doesn't exist in this file, so that will be scored at 0, which takes the PRVs would remain at 10 and the OVs will now be 10. So the guidelines will be changed to 0 to 11 months on this, and all objections are noted. So is there anything else to address with regard to guidelines?
No, Your Honor.
All right, Mr. Bandetto, is there anything you'd like to say on behalf of the people?
No, Your Honor, thank you.
All right, Mr. Malauer, is there anything you'd like to say on behalf of your client?
I would, Your Honor. As I've indicated in chambers, I monitored this case pretty much from the beginning. As the court noted through the trial, Mr. Raymer, and he indicated, I think, at the opening of his trial that he was intoxicated. This revolves around an alcohol issue on Mr. Raymer's part, and I think directly relates to his behavior. That said, he exercised his constitutional right to a jury trial. The jury heard all the evidence and the jury made its decision. And regardless of Mr. Raymer's behavior prior to that point, this court appointed our office. As the court knows, Mr. Raymer represented himself, so I know he's been cautioned repeatedly not to do so. He accepted the jury's decision. The court appointed us for the sentencing. And when I went to speak to Mr. Raymer a few days later, I would tell this court that Mr. Raymer's behavior was a 180. He was contrite. He'd accepted the jury's decision without question. And I think that's what he was looking for, was to have a jury of his peers make a determination of what occurred. And since he's been in jail, I've talked to him a couple times. He has attended regularly classes at the jail. He completed an anger management class at the jail. He initially, and I told the court this in the back, and think Mr. Raymer probably saw my reaction when I spoke to him a few moments ago. He said he'd been looking at legal books and works, and I thought, oh. And what he indicated to me kind of surprised me, because he said what he indicated was he had completely missed the boat as to how to behave and act in court, how to dress in court, how to address a jury, how to address the court. And he realizes, I think, the error of how he conducted himself and how he conducted that trial. With that said, Your Honor, I would ask the court to consider this as a sanction for Mr. Raymer. One, based on his ability to recognize what occurred and that the acceptance of a jury's decision in this matter, I don't believe, and I would ask the court to consider not imposing any additional jail time, but to impose a probationary term for Mr. Raymer. And the reason I say this is for several fold. First, Mr. Raymer does not possess a high school diploma. And I think with proper supervision, he could obtain that. And I think we all know, sometimes we take it for granted, but getting to the minimum of a high school diploma opens a lot of doors. Second, I think a term of probation would almost always, I've seen, involve him obtaining employment. And I think if Mr. Raymer can obtain employment, that also will help him along a path of being a productive citizen, as opposed to where he's been at. And I think that probably contributed towards why he's here today. And third, I think a term of probation would also assist Mr. Raymer, although he's been sober now for quite a while, but maintain that sobriety. So I think with those three components in place through supervision, this Mr. Raymer could go on to become a very productive citizen. And one thing I would note, there's no shame in this for Mr. Raymer. He can read, but I think he has some reading comprehension issues. And hopefully the probation department will take that into account if the court were to put him on probation when monitoring his progress. I am, and I don't get to say this very often, I didn't have much expectation or hope for Mr. Raymer when I first began to monitor his case and the times I spoke with him. But I do know, I think he has totally realized that where he was is not where he wants to be, and see that with some help, and there's no shame or anything wrong with getting the help. I think that's part of what the probation department's purpose is, that he can become a productive member of society, and perhaps even get to a level where he could be perhaps a leader. And I think that would be a remarkable transformation. So I'd ask the court to consider not imposing any additional jail time. The court could always impose something later if Mr. Raymer cannot follow through. So that would be our request.
Okay. Mr. Raymer, anything you want to say on your own behalf? So Mr. Raymer, I watched the video. You're not necessarily a soft-spoken person. I know it's kind of overwhelming being in a courtroom, but we have to be able to record what you say. So speak, attorneys are loud by nature. We all are. That's why we became attorneys. But you just got to raise your volume so we can record this, because if you appeal the sentence, we need the transcript. Okay?
Yes, Your Honor.
A little bit louder.
Yes, Your Honor.
Good. All right. Go ahead, Mr. Raymer.
I'm in agreement with Mr. Mallory on what he said.
That's it? All right. So Mr. Malaro and Mr. Bandito, I have a question. If you look on page 1 of the pre-sentence report, I forgot to address this with you. I'm back. Pending charges, domestic assault 4th degree, OWI, resisting arrest, assault 4th degree. What's an assault 4th degree?
It's out of Missouri, Your Honor. I have no idea. They're all misdemeanors as far as I know.
So these are misdemeanors in Missouri that are just hanging out there.
Looks like it.
Okay.
Mr. Sears looked into them and, I don't know if Mr. Raymer absconded from Missouri or what, but that there is a warrant pending for him for those.
Okay, okay, thank you. All right, so Mr. Raymer, you did actually represent yourself at trial. And one of the things that even the prosecutor said afterwards is that for someone with no legal education and training, you did a good job. You know, you behaved appropriately during the trial, you asked appropriate questions, and you interacted with both the jury and witnesses appropriately. So I do want to commend you because that shows you have the ability to present yourself properly and restrain inappropriate behavior. So I do want to say that even the prosecutor said he did a really good job. Not as good as an attorney would have done with the training, but for someone pro per, you actually did a good job. And so, and when the conviction came down, you took it and you didn't behave inappropriately, which a lot of people do in this courtroom. So I also commend you on that. So it sounds like from your attorney that you have appropriately used the time that you've been incarcerated to read up on things and to gain more knowledge and also think about what brought you here today. And because there was a body cam video, I got to see your parents and I believe your grandmother interacting and their comments, and you're on a path to destruction, right? Whether it's cirrhosis of the liver, something, you are definitely on a path to your destruction and nobody deserves that. So I hope that you are wholeheartedly serious about trying to change the path you're on. And, you know, I have a daughter who has a reading disability. It's not a big deal if you have one, but Adrian Ray Literacy Center at the Dominican Sisters, they have classes to help with that. You know, we have different programs to get your GED to help you with that. And I'm glad that these are things you want to take advantage of, because if you don't change your life now, you're going to end up dead, dying, or in prison. Those are your options if you do not make these changes now. Do you understand that?
Sure.
All right. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle, proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication of the law, and the protection of society. I am going to give you that opportunity that you are asking for, okay? So I'm going to place you on probation for a period of 3 years. And during that term of probation, you are not to use alcohol. You're not to use any illegal controlled substances. You are to take medication as recommended and as required. You can't possess any, like I said, any illegal controlled substances or paraphernalia. You may be asked to go get a substance abuse assessment. And when you do that, be honest about your addiction issues, because you have some addiction issues. It's okay. Lots of people do. The difference is wanting to do something about it, which it appears you do. I'm going to ask that you complete your adult education or GED program. We have great programs in our community to help you with that, to work at your own rate. You must not engage in assaultive, abusive, threatening, or intimidating behavior. The probation department can enter your home at any time for probation supervision to make sure you live there, to make sure you don't have alcohol or illegal drugs in the home. You must report any arrest or police contact, loss of employment, change of residence. You're on disability, right? No? Okay, you're gonna have to get a job and maintain full-time employment at least 30 hours, all right? There are jobs out there, and we have lists and lists of jobs. You must pay a crime victim assessment fee in the amount of $130. There is a $30 per month supervision fee, or $60 if we have to put a tether on you. I'm going to order court costs in the amount of $750. There's a $60 DNA test, and there is $136 state costs for the 2 felony counts, and then $50 on the disorderly person count. You're to report as often as required and obey and comply with all articles of probation. So I'm assuming that you're not in a position where you think you need an inpatient program at this point because you've been incarcerated for over 6 weeks.
I don't know what that means.
So sometimes when we have people with alcohol or substance abuse issues, they need to go to like an inpatient treatment program.
Yeah, I've been sober for 3, I've been sober since that incident, so.
Right. Okay, good. So you may be ordered to do outpatient treatment. You got to do it, all right? I'm going to put a curfew in place from 10 p.m. to 6 a.m. unless it's your employment that requires you to be out after that. And I'm going to give you credit for 49 days already served on this file. Okay, I'm not going to give you any more jail. You're going to get out today. And then that's on count 1 and count 2, all of that. And then on count 3, as I said, there's a $53 state cost. I said 50, but it's moved up to 53 now. And then $75 crime victim assessment fee, and I'm just going to give you credit for time served on that one. All right, 'cause it's a 93-day misdemeanor. Okay, so Mr. Reamer, you know, your family's here because they love you, but they're kind of at their wits' end with you too. You know what I mean? And they want you to have good things. And I think they love you very much. And so you've got a lot to live up to. And I think you can do it. All right. All right. Mr. Moore.
Yes.
He's going to be released today. What are your instructions for him?
Okay, I want you to report up to the probation department. Okay, and if Agent Teskey isn't available, you're going to schedule an appointment with the secretary there to have a meeting with her. Okay, so make sure you report, let them know who you are, why you're up there, and Agent Teskey's who you're going to schedule an appointment with if she's not available. Okay.
Does she need to report on Tuesday or whatever day they give her?
Well, I want him to come today to come up to the office and make sure we have it, you know.
Okay, so when you get out of jail today, they're closed from 12 to 1 for lunch, but you need to report to the 3rd floor probation department. They're going to set up a time for you to go over your probation terms with your probation officer. Keep a copy, know them, because you can't come back later and say, I didn't realize that, okay? And then they'll set up a schedule for you to report on, all right? And that means no alcohol, so you don't get to celebrate by getting out of jail by going to have a drink, all right? Okay, now you do have the right to appeal this sentence, so my bailiff's gonna hand down to your notice of right to appellate review. He's gonna have you initial and date 1 copy. Today is June 5, and the other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days or drop it off, all right? All right. Anything else, Ms. Adams? I don't think so.
I don't think so.
All right. Mr. Jagermer goes in, your guy's not in custody, right? Yeah. Is he here?
It should be on Zoom.
He's not been on Zoom all morning. Want to call him? Yeah. I've had nobody in my Zoom waiting room. Do you want to reach out to him? I got drug court, so go ahead and call him. The judge keep trying. They listened to the recording and it sounded like a judge.
Thank you, Judge.
Oh, Mr. He was laughing. Okay, I'm gonna step off the bench. If Michael is able to find his client, that would be great. If not. All right.
Yeah, because everything got up and live.
I know, and I'm like,
Mr. Hurton, you cleared the courtroom. Or maybe they thought you said Mr. Hart to clear the court.
I don't know,
Wow.
but I would never. Huh.
The state. how
I
are
did
you?
do fine. How are you? So that was a nice one. That was a nice swearing in yesterday.
Yes, it was.
Yeah, she seems like a nice young lady. How are you girls? All doing okay? Your 4 girls?
Abby's making me crazy.
Abby is?
Yeah, she's over in Italy.
Oh, yeah. How's that going?
Apparently really well. Much to my dismay.
Good for her.
Thanks.
What a great opportunity for her.
So if my blood pressure is not, I don't know.
Oh my gosh. How long is she gonna be there?
She comes back on the 25th of this month.
So how long has she been there?
She got over there on May 7th.
Wow.
And she's
I wish-
study abroad she's learning Italian.
Is she really?
But it sounds more like she's sightseeing. She's been to Venice, Milan, she was in Milan over the weekend. I said, are you going to class? She goes, yeah, but we do field trips.
Oh, Sam. And this is her first year or no, second?
She'll be a junior actually, but
Really?
this last year was her first year admission.
Wow, that's great.
But she got enough credits from the academy. that she
Oh,
can do.
there you go. That's good. Good for her.
Yeah, no, she's doing well.
That's great. Well, you haven't lost any hair though, Sam.
Oh, you have to have hair to lose.
Yeah, there you go. Take care. Have a good
Someday
weekend.
Margot, you will find that out.
Yeah, there you go.
Have a good day.
You too. How are you, Michael?
How you doing?
I'm okay, thanks.
Spelled Sam's last name.
What's
I
that?
just spelled Sam's last name.
Molaro. You're welcome. Did you get a hold of him? No?
No, I may have an explanation on where he might be, but I'll just.
Gotcha. Okay, sure. No, you really are. Let me go out there and find it, tell her that, Michael.
All right. Mr. Coast, are you staying on for Demoulin?
I am, Judge.
Okay, so this is in the matter of the people of the state of Michigan versus Joshua James DeMolin, file number 25-22183 FH. I am Michael Dagger Margosian appearing on behalf of Mr. DeMolin and Tom Moore from MDOC and Darren Close for pretrial services. So he obviously appeared for the pre-sentence interview. We do have a report generated. Mr. Coast, do you have an update on him?
I do, Judge. He did have a contempt back in April. He tested positive for meth on 4/7. But since that time, he's done a really good job. He's been seeing me twice a week, every Monday and Friday. And ever since that positive, I haven't had any additional positive meths. So with that, I'm okay with the contempt being dismissed.
Okay, so I'm not going to dismiss it today, but I know that Mr. Dagger Margosian has reached out to his client. Usually if they show up for the PSI and they're testing well, this seems to be an accident. So Ms. Adams, could I get the next available sentencing date, please?
Judge, that would be June 12th at 8:15.
Are you available that day, Mr. Dagger Margosian?
I am, the only thing I'll add, Your Honor, is, I did speak with Mr. DeMolin yesterday, and in passing, he said that he had like a bench warrant, he's on probation downstairs, he had a bench warrant, but he was told that that wouldn't result in an arrest. The only thing I can think of is maybe he misunderstood that, so.
Okay, all right, so I'm gonna adjourn it to June 12 at 8:15, just get him in here and we'll deal with it. Is that a new case downstairs?
No, he's on probation down there, so it's already been.
I have no authority or control over district courts,
I
so,
know.
all right, but, there's not a recommendation, let's see here. You know, this one's fine, so, yep, just tell me to get in here. All right, thank you very much. Thanks, everybody.
Thank you, Judge.
Thank you.